All right, we are on video recording number 78. So we're down here under agreement of sale, which we finished last time. The modules on agreement of sale are 65 through 77, so quite a few there. The deposit money notice is going to be today, so 78. So this is an example of a deposit money notice and kind of what it looks like. You see that okay?
Mhm.
Okay, let's move that over here, and we'll make this a little bigger. So if you were to look back in our earlier trainings on like the on the sales processing sheet and what when you submit a file to Anita or our transaction coordinator, what documents are required. There's a couple documents that are required by the brokerage and by the state real estate commission as like disclosures. So one would be the consumer notice, the buyer's agency agreement, the buyer's cost sheet, which we'll go over here in a later on in another training. The agreement of sale contract, of course, are all required, and this is another required like one-page document. It's not complicated.
Mhm.
The purpose of this document is to let the buyers know that there's this thing called the deposit money notice, or there's this thing called the deposit money, which is a check that's given when you put in an offer in Pennsylvania, and it goes and it's held, and there's governance over it. There's like rules, and we talked in the agreement of sale how like on page 2 we put like $1,000 deposit the buyer put up, and it said on the fine print that it's held by the listing broker for the seller unless otherwise stated here was one of the things on that contract. And then later on in the contract there was a whole paragraph on the deposit money that said we ask you to check a box always that said sellers limited to retaining these sums paid by the buyer. And then above that there was this whole paragraph that said just because the buyer terminates an agreement because of an inspection or a mortgage contingency or some protective clause in the agreement, even though they're entitled to get their deposit back per what that clause says, the truth is that the broker that holds the deposit isn't allowed to give it. They don't have the authority to say, my interpretation of the agreement is that you get the deposit back, Mr. and Mrs. Buyer, and so here you go. They can say my interpretation of the agreement is pretty clear. You canceled the agreement because of the foundation was falling apart, and you were within the terms of the inspection contingency. They can say that, but they have to follow that up with per the deposit money guidelines in the contract and per this notice. I don't have the authority to give it to you. The only way the broker can give the deposit is if both parties sign an agreement that they're agreeing to let it go. So the deposit money account that the brokerage has is kind of this neutral account that has this separate set of rules that says this is nobody's money. It's not the buyer's money. It's not the seller's money. It's not the broker's money. It's in this account. And the only way we can release it once it's in this account is by a consensus, a unanimous consensus of all parties. Otherwise, it just has to stay there and nobody gets it. With the exception of the statement in the agreement of sale that says, in the event that 180 days go by and there's no litigation, then automatically it can go back to the buyer without a consensus. Mm-hmm. But during that time period, 180 days is the default. It can't go anywhere unless one, a judge awards it through litigation, then we can release it by order of a judge, or two, a consensus. Buyer says, or seller says, yep, I agree, it goes to the buyer, and they both sign. Or they negotiate, and the seller says, I want half because of my time off market. And the buyer's like, well, I don't want to fight it. I'll fine, give them half and give me the other half. So that's the only way it can go. So the above amounts are estimates and do not include fees for certification and or inspections required under the agreement with each property and or mortgage lender. Funds required to complete closing must be by cash or certified check. Deposit money notice to buyers. 1. The selling broker is HH&E Realtors and will accept your sales deposit for the transfer to the listing broker, RE/MAX, who is agent for the seller. So this tells the buyer that we're the selling agent, the buyer's agent, and we'll take your money and we'll give it to them. It always goes to the listing agent. and just back to when you look at the agreement of sale. Well, I don't know what that is. Right here it says deposit $1,000, all funds paid by buyer, including deposit. Sorry, wait. Here we go. Deposits will be paid to broker for seller. So in this case, it is Remax. Seller's broker, Remax. So deposit money will be paid by broker to broker for seller, unless otherwise stated here. So we almost always leave that blank. Who will retain deposits in an escrow in conformity with all applicable laws and regulations. Okay, and then down later in the agreement, it talks about what we just discussed, which is default, termination, return of deposits. If there's a dispute over the entitlement of deposit monies that is unresolved 180 days after the settlement date or following termination agreement, then broker holding deposit monies will, within 30 days of written request from buyer, distribute to buyer, unless we're in receipt that the dispute is subject to litigation. Okay, so this document is just this kind of covered all disclosure that is stating that it goes to Remax. The agent for seller is a Pennsylvania licensed broker who's required to hold it in escrow. If it's in the form of a check, it must be made payable to broker for seller. We acknowledge receipt of this notice. The buyer acknowledges receipt prior to signing the agreement of sale. Receipt a copy of the statement. Receipt a copy of the statement of estimated buyer settlement costs, estimated monthly payment, and deposit money notice and approved information contained herein. Buyer signs. And then in the agreement again, this is the law. It says on the last page, that just one more time, they've received the consumer notice, they received the closing cost estimate that we do for them, and the deposit money notice. And then if it's built before 78, the lead-based paint. And so this document again is just saying they got the closing cost estimate and estimate of payments and the deposit money notice. And then home protection plan waiver. Not really sure, to be honest with you, why this is on this form. This is like an in-house form, and this is just them waiving that they have the right to get a home warranty, to have the mechanicals of the house protected, and they're declining it. And so if they're not declining it and they're getting a home warranty, they're not going to initial there. And this is very important. They're acknowledging that we advise them of their right to order inspections of all this stuff, and that's a good idea. And that, and then we're encouraging them to get a title insurance policy as well. Okay, so this is just this one page, contains all these extra things that we're encouraging them to do. Any questions?
Only on that third bullet point, it says the deposit be made payable to the broker for the seller.
Mm-hmm.
So that check is made out to Remax, or?
Yep,
okay.
Sure is. Yep, so we take it and we can transfer it, according to this, to the listing broker Remax.
Mm-hmm.
And if you look in this file, deposit check is right here. You can see there's a copy of it.
Mm-hmm.
And out to Remax.
Cool.
Good deal?
Mm-hmm.
All right.